Well, thank you, Mr. Chairman. Let me state from our experience, I had the opportunity to chair this committee for a number of years, and we've had problems that some have been pretty serious. And I categorize them in three groups. One is that the states during this process seem to be ignored. The second thing is that the delisting just never happens. We talk about it, and it never comes about. And third, the stakeholders and the land owners are pretty much ignored when these are coming. So I'll start with you, Governor. In Oklahoma, we set into motion, and you'll remember this, Dan Ash, because you were there at the time, a 5-state partnership with New Mexico, Colorado, Kansas, and Texas. Now, we got together. We spent a lot of time on this, and we sat down and decided what we're going to do, the problems facing with the lesser prairie chicken, by bringing all the states together, the agencies together, industries, conservation groups, and private landowners. Despite this, the Fish and Wildlife listed the species as threatened. That listing was so wrong that the courts reversed it. And yet, Fish and Wildlife continue moving forward. Now, as a former governor of a state, isn't this a little frustrating when you go to this much work? That's not an easy thing to do, to get 5 states all in one room for a long period of time.
Senator, thank you. I'm familiar a bit with the lesser prairie chicken, and obviously it's complicated. From my experience, what I would say is they ought to be required at the outset, if they're going to list, to tell you what's required to get it delisted so that that doesn't continue to move. Secondly, they need to recognize that if they want to do this on a scale that does something for the species, that multi-state cooperation is difficult and it's expensive to put together. And at some point, they have to become a partner with the states. And the problem with the Act is it has the cooperation component, but it has this role where they are also judge and jury. And at some point, those two roles have to be reconciled. If you're going to be a partner in putting together a recovery effort, and yet you have to be guarded, as I say, they always would come and talk to us about the wolf and the bear and that, and say, but we really can't say anything because that would be pre-decisional. Mm-hmm. We have to somehow reconcile the fact that cooperation means people actually can sit down and work together. So you can't be, the problem I have with it is that they're judge and jury, and at the same time, they want to be a cooperator, and we have to reconcile those two roles, because what happens now is cooperation with the states is clearly secondary because the decision-making role is so subject to judicial review.
Mm-hmm. Excellent. Mr. Myers, getting back to the delisting dilemma that we're sometimes in 1989, the Fish and Wildlife listed the American burying beetle. This is the hardest thing for me to explain back home, not just to road builders, but to farmers, why they cannot do something because there's a bug down there. And the endangered species, because it had disappeared from its former range. So that was the reason for doing it in the first place. Now, it seems the information relied on for the listing was based on anecdotal historical evidence and poorly performed surveys. Yet, nearly 30 years later, the beetle is a thriving and stable species. But we're still not delisting. Mr. Myers, what do you think? How could that system be improved?
Thank you, Senator. I guess a couple things I would mention. One is, I don't know the specifics of the case, but I would first mention that many states, in fact, have very good data on species, and I think it's important to assure integration of state data into any decisions. But relative to the delisting, I think as Governor Freudenthal pointed out, specific triggers are very important, and I think integration of those triggers at the upfront in the listing process is also key. But once those triggers are obtained, whether they're habitat or population objectives, that should key and bring forward the delisting process. Of course, often the courts end up becoming a very big problem in moving those decisions along.
Yeah, what I hear from both of you is that maybe a system should be set up when listing goes into place, state at that point the conditions and the timeline of delisting, and then expand that even further and go into others that are already listed, because there are many on that list right now. And the last question that I have, Mr. Chairman, would be for Mr. Holt. Our Oklahoma farmers and ranchers are just now learning about a petition to list the monarch butterfly under the Endangered Species Act. They weren't aware that there is a problem. They didn't know anything about it until they woke up and found that that was going on. Well, the monarchs need milkweed to breed, yet milkweed is poisonous to cattle. It's clear that a listing will directly affect our agricultural community, yet landowners, they were left in the dark when it began. What kind of improvements should we, because we are talking about modernizing now. Changes are going to be made. What's your thoughts about that, Mr. Holt?
Well, thank you for the question. I would respond that I think the communication to farmers and others might be enhanced by a better line of communication with general farm organizations, commodity groups, state departments of natural resources. I would admit that when I or my neighbors or colleagues arise in the morning, the first thing we think about is not the Endangered Species Act. It is producing our livelihood in production of food and fiber. So opportunity to share that information, the concerns before they're actually listed, and then the opportunity to work with states with incentive-based programs that could maybe solve the situation before we get to a listing situation. Those processes could be very helpful, I believe.
Thank you very much.
Thank